Hey guys, I'm Ted, and I'm here to pick right back up from where we last left off in our last lecture on Laissez Faire. In our last lecture, we discussed the origin of the term coming from Adam Smith's book, his little tract, the Wealth of Nations. We also discussed the fact that there never really was a hands-off approach to business in the United States, that the government always lent a helping hand to business. And we also discussed the early opposition, the opposition presented by the Democratic Republicans to laissez-faire or hands-on approach to government. Now, the Republican Party, that is to say the Republican Party in the 1850s, created an alliance of all segments of the free states' populations that favored government assistance and action. Now, these, of course, included protections from competing with slave labor, free land for homesteaders, a high protected tariff for manufactured goods, and of course, with the election of Abraham Lincoln and the secession crisis, the major political barrier to the passage of their entire Republican platform from the 1860 election was removed when the slave states decided to uphold their representatives, decided to attempt to form a succeeding republic. So they decided to form a new slaveholding republic. They removed all the blocks, all the impediments in the United States Congress and United States federal government to the implementation of their entire program. It's really the only time ever that a political party was able to input or establish their entire political platform as is, with no alterations whatsoever. Now, the Democratic Party, while the Democratic Party of the 19th century, I should say, while favoring a low tariff, also came to favor government involvement in the economy after the Civil War. Now, there were a number of factors to support this. From the post-redemption rush to industrialize, and of course President Cleveland's actions during the Pullman strike. Even the reform movements of the late 19th century did not want the government to stop its promotion of business. They wanted government to regulate business. They wanted government itself to be hands-on and to regulate business. Furthermore, as time went on, the businesses actually came to favor government regulation as well. As the larger corporation, the larger firms found that it could more easily afford to follow, while newcomers weren't able to do so. The cost of fitting into government regulated industries and so forth, the cost of operating under the government regulations, which were just too great to bear for these new industries in the 19th century. So government regulation actually served the bigger corporations, actually served them to help break down their sort of apprehension towards competition. They didn't really have to worry so much about competition. Because competitors found it very difficult to compete with them under all the government regulations. Now, businesses at the same time were also effectively lobbying the government for actions it desired, and they were also lobbying against actions they did not desire. This was done by the need for elected officials to maintain economic prosperity and the placement on the Supreme Court of a number of former corporate attorneys during this time period. So how did the myth really originate? Well, the United States government, as we have seen, was never completely laissez-faire, but different groups from time to time have favored restrictions on government's role in regulating the economy. Such restrictions have been proposed and defended as laissez-faire policies, though they were not. Now, laissez-faire has been used by different groups at different times to lend ideological support to promote their own interests. The years of the late 19th century and early 20th century were years of rapid economic growth for the United States. I've said it a number of times. Other people have said it a number of times. It really can't be said enough. It really can't be oversimplified. Um, uh, this era saw unfathomable growth. I mean, industries sprouted overnight and became dominant in local communities and became pillars of the national community, basically overnight. The steel industry was in this magnificent boom. The oil industry in this magnificent boom, and we've already discussed them. We've already discussed them. When we discussed the careers of Andrew Carnegie and John D. Rockefeller. There were also these were also years of intense political and social conflict, and these conflicts generated the reform campaigns of the populace and the settlement houses, the immigrant aid community campaigns, and so forth. Now, the factories, the railroads, and the mines that generated massive wealth for owners and investors also had an insatiable appetite for cheap labor. The low-wage laborers endured long hours under dirty and dangerous, really abysmal conditions. And those conditions led to deaths by the thousands. And this was a yearly occurrence in which you can say that these industrial workers, these mine workers, thousands of them would die yearly from work conditions and from overwork. Now, farmers and ranchers that raised and produced livestock had to ship their produce and their animals on railroads, and these railroads charged exorbitant rates. These rates led many workers to join unions that pressed lawmakers to set maximum work hours for railroads, maximum work hours and minimum wages. While farmers lobbied for government regulation of the railroads and grain elevators. Now, we've covered these topics in previous lectures, but we have to examine the socio-economic or political atmospheres of the struggles, and we also have to look at some legal cases that emanated from these struggles. Now, the struggles essentially became a legal question, and the question was who decided what policies were necessary and what policies were reasonable. The elected executives or the legislatures responding to popular sentiment, or unelected judicial figures guided by their interpretation of the Constitution. That was the big question surrounding all of those issues. Now, the justices of the Supreme Court looked to the Due Process Clause of the 14th Amendment, which protects liberty and property against state deprivations. The ways and means by which the courts applied the Due Process Clause set the political and social tone for the era. The question and the approach of the court also requires additional reviews of the intense political battles and the intense battles over judicial doctrine. During this era, a number of prominent legal experts debated the exact meaning of the Due Process Clause. Now, one side had legal thinkers who thought that judicial officials should limit themselves and their review of a law to the process by which the law was enacted. If legislators had followed all the rules by which laws were to be created, and if the laws were within the reasonable grasp of a state's policing powers, then the law should be upheld. This became known as the doctrine of the police powers, or procedural due process, and the entire legal basis rests on the duty of lawmakers to protect the public health, morals, welfare, and of course the public safety. Now, on the other side of the debate were those who championed what became known as substantive due process. Now, under this process, judges were free to examine all aspects of the law to see if it deprived anyone of their liberty or property, if it was agreed to, if it did the law uh, if it was agreed to that it did, the law could be struck down as unconstitutional. Sorry about the delay there. It's I was sort of running ahead of myself in my mind over the direction of where we're going with that statement. Um, Now, the doctrine of substantive due process allowed judicial officials to substitute their views for the views of the elected officials. Now, one of the most well-known advocates of substantive due process was Thomas Cooley. Thomas Cooley was a law professor and a judge from Michigan who wrote a very influential book, a treatise on constitutional limitations. And in the book, he summed up the entire argument and its entire stance in the book by saying a legislative enactment is not necessarily the law of the land. Laws that passed the procedure test of the due process violated the Constitution if they represented arbitrary interference by the states with rights to private property. This outlook became a key theme in the liberty of contract doctrine and allowed for laws that did not violate express constitutional rights to be struck down during this era. The liberty of contract doctrine was also applied to agreements between employers and employees over wages and working conditions. Keep that in mind. In addition, the contracts or the agreements between farmers and railways lines over shipping rates were also protected by the liberty of contract doctrine, because again, that's an agreement between the farmers and the railway lines over shipping rates. Now, it is at this point that a number of cases start to come before the Supreme Court of the United States, and the Supreme Court steps up to the plate and begins to deliberate, begin to hand out verdicts that greatly shape the understanding and the collective destiny for like the rest of the 19th century of these major corporations, and really begin to shape the ideas of laissez-faire in the Republic. In 1877, the legal dispute to involve the liberty of contract doctrine, a legal dispute. Sorry about that. A legal dispute involving the liberty of contract doctrine were brought before the United States Supreme Court. In 1877, and 1877 itself was a bitter and a bloody year for the Republic. The effects of the Panic of 1873 were still being felt. Redemption was taking place unadmonished in the former rebel states. The Panic of 1803 led to farms being repossessed by banks. Workers were thrown out of work. And in Illinois, farmers were irate at the high rates they were being charged for grain storage in Chicago. As wheat poured into the city from the railways, it was stored in grain elevators and warehouses until it could be sold to millers or bakers, or even just exported to distant locations. Now, the farmers had lobbied the state legislature to set a maximum price of 2 cents per bushel on grain storage. Now, the company of Munn and Scott, Chicago's, which was then Chicago's largest grain storage company, refused to obey that law. They were convicted by the Illinois State Supreme Court of violating the grain storage price laws. The company, undeterred, filed an appeal with the United States Supreme Court, arguing that the state legislators had passed a law that deprived them of their liberty to engage in business practices free from the arbitrary interference of the state of Illinois. The company's lawyers pointed to Cooley's ideas as justification for their ideas. Their Supreme Court argument was rejected by the court. The court, and in particular, Morrison Waite was still Chief Justice at this time in 1877. Chief Justice Waite wrote the court's majority opinion, and he wrote that the laws were a reasonable regulation of a virtual monopoly on the grain storage business. Now, this decision will be an early battle in the war that was to come, because 10 years later, another case, this time a case arising in Kansas, where the temperance movement was in full swing. In 1881, the Kansas state legislature passed an act banning the manufacture of intoxicating liquors. Now, the county attorney of Saline County promptly charged a local brewer, Peter Mugler, a German immigrant, with violating the law by selling beer to the county's very large German immigrant population of farmers and factory workers. Now, the case reached the Supreme Court in 1887, and Chief Justice John Marshall wrote for the court in rejecting Mugler's claim that the prohibition law deprived him of both liberty and property in a violation of his 14th Amendment rights. Harlan cited the Munn case in stating that society has a right to protect itself from the alcohol business. Harlan agreed that the legislature had the right to decide what laws were just, but also intoned that the legislature's interpretation of just were reviewable by the courts. We'll break here and we'll come back and we'll finish up our discussion. We'll finish up our overview of Laissez Faire with a couple more cases. As always, I am Ted. Hit like, subscribe, and comment. Let me know what you thought about this lecture. A lot of dynamic things going on. A lot of actions going on. Very much curious to know what you think about this. I'm always curious to know what my classes think about it. I want to know what you guys watching the video think about it. These videos always strike people differently. The information always strikes people differently. If you agree with what the court was saying, if you disagree with what the court was saying, let me know. I'm curious to find out. I'm Ted, and I'll see you guys next time for another lesson, for another lecture.